I got a chance to work at Kenya National Highways Authority. And during this time, of course, one of the major things they do is contract administration and management, especially in the maintenance department. And during this time, because I was fresh from graduate, I really didn't have an idea how FIDIC contracts are actually applied on site in projects. I had read about it of course, during school and a bit of research here and there, but I didn't have a very deep understanding from someone who has already practiced. And I think that is always the bigger challenge with us because there is the theory that we are reading, the blogs, the materials, but then there is the actual application from the perspective or from a contextual perspective. You need to understand every contract, every project will be, the contract will be structured very differently. Then how do you as a contracts manager approach it? And I remember now when I got promoted a few years later, I got to a project that has a lot of problems, a lot of contractual issues. And one of the glaring one is we had land acquisition issues, which was pending. So this means that the client was unable to provide access to site. And therefore, this resulted to delays in the project. The contractor applied for EUT, and we needed to do the evaluation and do all those correspondences in between. Later on, of course, when the EUT was awarded, there was now need for us to evaluate. He submitted now the financial claim, requesting compensation for his time. And then now this was one of the most difficult part for us also to substantiate every claim that the contractor raised. This is when I really got to interact with him at a deeper level. He got to guide me through these. And I'm very grateful to say that that contract was actually settled through his help. So Barasa Ogeti is a FIDIC certified contracts manager with a strong academic foundation in civil and structural engineering and construction engineering management. That is his master's. He currently serves as a contract manager at a data center construction firm that is overseeing major projects across Africa, including Angola, Mozambique, Ethiopia, DRC, Tanzania, Ivory Coast, and Uganda. And I remember the recent one that they launched was in DRC. He has over 9 years of experience. Very in-depth expertise in FIDIC contracts and contract administration, dispute resolution, income protection strategies. And I think his background includes a significant tenure at consulting firm where he has handled complex claims and contractual issues in infrastructure projects. He has worked both in East and West Africa and as well as Southeast Asia. I remember I met him when he was in Southeast Asia. And he is here today to teach us in the easiest way possible. He is very good at that, and I hope that we all get to learn. Ladies and gentlemen, let us welcome Engineer Barasa Ogeti. Senior, please, are you able to take it over?
Hello, James. Is my audio
yes,
clear?
Please.
Can you hear me? And can you see me? Okay, good.
I cannot see you, but I can hear you.
Oh, really? Okay, let me just adjust.
There you go. Super.
Okay, that's better. Okay.
Super. Yes, I can see you. Let me know whether you can be able to share your screen.
Yes, I'm sharing my screen. I hope everybody can see it.
Yes, I can see. Please drop a 1 in the chat box if you can see the screen. Super fantastic. I like that. Take it over, engineer. Thank you. You're welcome.
Perfect. Thank you. Thank you. Thank you, James, for putting all this together. And thank you to all the attendees for taking time to join us. I'll make my presentation as brief as possible and as easy as possible, as James has said. And I know we all have a football match to catch in a few minutes' time, so I'll not keep you here for long, and it's not my intention to keep you here for long. I'll make it as brief as possible and as interesting as possible. Thank you once again, James, and thank you for everybody who has found time to join us. I'll start my presentation by telling you what we're going to talk about, and then I'll move on a bit to explain slightly, though James has done a very good job at it, about who I am, and we'll get into the meat of the matter. So today's topic is fundamentals of FIDIC contracts in construction. Now, I'm informed, just like you are, that we're going to have 3 sessions. That's the first time I'm hearing of this. So for today, I'll restrict my presentation to fundamentals, right? The basics. So for gentlemen like Mark or Rocco, who have a bit more of advanced knowledge, you may find this to be pretty basic. And for others who have beginner knowledge, like I had Alice, whose question was Alice from Rwanda, who said, what is FIDIC? We'll answer some of those questions as we go along. And for many of you who are interacting with FIDIC perhaps for the first time or are at a beginner level of interacting with it, I believe at the end of this first session, you'll have a basic knowledge of the fundamentals. Then in the future sessions, we'll get deeper into the meat and the bone of the matter. That is me. That's how I look like in person. That's the best photo I could find of myself. But generally, I look like what you can see on screen, and a mixture of that photo, and also a mixture of what is on my ID card, my government ID. But that's myself. My name is Barasa Ongeti. I work as a contracts manager at a construction company called Raxio Data Centers. And what we do is we build data centers. But prior to that, as James has said, I've had a sufficient experience across Africa and in parts of Asia in carrying out various projects. I've been privileged enough to do roads projects, water treatment projects, port projects, and currently data centers. So I have rather diverse knowledge of some of these projects. My LinkedIn is at the bottom. I invite you to tap away and add me. I'll be pleased to interact with you at any time on any topic, not only engineering or roads or projects. I speak about very diverse matters, and I'll be happy to connect with you on LinkedIn. Barasa Ongeti is the name, and as you're told, with an S, not with a Z. So what are we going to talk about today? Very briefly, we're going to talk about the basics of a contract. I'll start from the very basic. What is a contract? I believe some of you have legal backgrounds here, perhaps. I know Mark is one. I don't know if anybody else has a legal background. Most of you have engineering backgrounds. So we'll start with the basics, then build up to what we know. We'll move on to principles of a contract. How should a contract be structured? And perhaps that will answer Nonkuleko's question about why use this contract and not that other contract. And then we'll move on to why use standard contracts. And then we'll briefly touch on contract and the law. I'm not a lawyer, so please, at that point, you'll excuse me. I'll be very brief, but we'll still cover the basics. Then we'll get into the meat of standard forms of contracts. I will give you an overview of FIDIC standard forms. I'll give you details of other forms of contract, which are called standard forms. Then we'll get into the FIDIC, how it started, where it went, and where it is right now. And then we'll move on to the core types of FIDIC. And I believe at that point, we'll be able to answer the question that was raised by Daisy from Uganda. And then we'll also touch on the roles of parties in FIDIC contracts. So I believe that at the end of this session, you should have a basic knowledge of the fundamentals, such that whenever somebody mentions FIDIC, you do not think perhaps it's a name from a footballer's name, perhaps from the Icelandic countries, because those names end in IC always. You'll understand exactly what FIDIC is. Are we together up to there? Shall we begin? Basics of a contract. So what is a contract generally? I don't know if the microphones are activated and if anybody can shout out what they think a contract is. Anybody,
Yes.
just one person to shout out what you think a contract is.
It's a legal binding agreement between parties.
A legal binding document between two parties. Anybody else?
Hello?
Yeah.
Yes, a contract is an agreement between two parties. Between a client and a contractor. Something like that.
Okay, perfect. Let's move on with those two definitions. I like both of those definitions, a legally binding document, and somebody else has said an agreement between a client and a contractor. So let's move on with those two definitions. A contract is a legally binding agreement between two parties, could be two or more, but here I say two parties, enforceable by law. Now the operational words here are two. One, legally binding, and the second, enforceable by law. Why do we say legally binding? It means that when two or more parties come together, they're agreeing that the matters that are written down in that agreement are binding to them under the law. And should anything fail, these matters that they've agreed upon will be enforceable by the law. Okay? And that's a very basic definition of what a contract is. So a contract is only valid and enforceable if the agreement contains evidence of certain elements. What are these elements? And this is basic contract law. Number one, there must be the intention of the parties to be legally bound. As we've heard from the second description, a client and a contractor as an example. So the client is party one and the contractor is party two. Party one and party two must have an intention for them to be bound legally. And that is why perhaps if you look at any contract that you have near you, it will start with usually the terms such as, with those complex legal languages, and it starts with, whereas party A and party B intend to carry out the following, and whereas, and so on and so forth. If you look at that contract, it actually covers these elements step by step. It starts with the intention, then it moves to an offer. Okay, an offer is party one stating that I've offered to do A, B, C, D for a certain price, which we'll come to in a second. And party B accepts this offer and says, I accept that party A will offer me the following services, or construct the following road, or build the following dam, or construct the following bridge at a certain price, which is what we call a consideration. So a consideration is money or something of interest being exchanged between the parties. So again, when you read those preambles, whereas party A and party B have come together with the intention to be legally bound, and party A has stated that they are capable to construct a bridge, and party B has stated that they're willing to accept this construction of a bridge at the price of $7 million United States dollars. You've covered those elements in that agreement. Okay? Now, the other three, the remaining three, is that there should be a capacity of the parties in terms of age and mental ability. Just for example, you cannot have, in most jurisdictions, you cannot have a contract agreement with an underage person, okay? A person below the age of majority in your jurisdiction. In common law jurisdictions, it's either 18 years or 21 years and what have you. Or you cannot have a contract with a person who's mentally incapacitated, for example. A simple contract is the sale of land. You cannot sell land to a person who's either senile or, out of their mind, and so on and so forth. There must be certainty of terms. What are these things that you're agreeing to do? Okay, and that is what becomes a contract. Lastly, a contract must be legally enforceable, and that means that this contract must be presentable to the law. So it cannot be a contract that is illegal. You cannot have a contract to sell marijuana, for example, because it's illegal. You cannot have a contract to traffic human beings because that is illegal. Okay? So the terms must be legally enforceable for that to be a valid contract. If any of these items are missing, then that is not a valid contract. So just to quickly recap, we have an offer. Somebody says, I'll do something for you. We have an acceptance of the offer. I accept that you'll do this thing for me. There's consideration, which is a value. Something of value is exchanged, okay? Even if it's 1 Ugandan shilling. Something of value must be exchanged. And there must be certainty of terms. What are these terms of what are these terms that we are exchanging? If I'm purchasing a vehicle from you, for example, I must be certain that the vehicle registration plate is UGB001A, and it's blue in color, and it's a Mercedes-Benz C200, for example. I'm certain that those are the terms I'm purchasing it, and it is located at a showroom, such that when you bring to me a Toyota Camry, yet the terms specified that you should provide me a Mercedes C200, then we are in breach of the contract that we had agreed. So the terms must be certain, okay? They must be legal. I've just given an example of why you cannot have illegal contracts, and we must both have the capacity to engage in contracts, and we must have the intention to enter into legal relations. Once you have all those 7 items, then you have a contract in place. And that is a contract, okay? In most jurisdictions, again, a contract can be written. In other jurisdictions, a contract can be oral. It's important that you check with your jurisdiction whether oral contracts are agreed upon or they're not. Now, if you remember the definition we started with, we say that a contract must be enforceable by law. This brings us to the next slide, which we're calling the governing law. Governing law is the legal framework chosen in a contract to resolve disputes. You've entered into a contract and you've agreed that you have the intention to be bound legally. What this means then is that you are engaging in an agreement which shall be governed by a given legal framework. Should anything go wrong within that agreement, this law, called the governing law, is what will resolve the disputes. So the contract defines how 2 parties agree to do business or to engage in services. And how these terms are effected and interpreted will vary by different countries' laws, okay? We've seen very various nationalities in this call today, and you can understand that the law varies from what it is in Rwanda to what it is in Uganda to what it is in Zimbabwe and China and the United States and so on and so forth. The governing law identifies which law will apply to the contract. So there are 3 main legal systems. We have a common law, we have the civil law, we have Islamic law. And I think there was a question on that. We won't delve into those. I think that was also by Mark. Pardon, Mark. Those are a bit advanced topics, and we may cover them in future seminars. 3 main legal systems, and we'll describe them just briefly what they're all about. There's a hand up by Timothy. I'll take a break for questions, Timothy, so that you can just note down your question. I'll take a break, and then we'll come back and cover the questions. The 2 photos there you see are just for dramatic effect. One is from Uganda. I think that's the Buganda Kingdom. Somebody can confirm. And the other one is from ancient England, I believe, and that must be the Queen. It's just there for dramatic effect. It has nothing to do with today's seminar. As I said, a governing law clause provides certainty by identifying the legal system that will apply to interpret the contract. It enables the parties to select a specific law, regardless of where they reside or where they signed the agreement. So what this means is that regardless of whether I, as an employee of Kenya National Highways Authority, sign a contract with Uganda specialist contractors in Uganda, regardless of where we are, we can state the governing law that we want our contract to be governed by. It need not have any association whatsoever with the parties or the contract location. In most cases, I must add. Some countries specify that the governing law must be the law of that country. But in most countries, especially in the common law areas, you're free to choose whichever governing law you want. So a Chinese contractor is the example I've given there, working in Uganda for a French developer can choose the United Kingdom law as the governing law. Here is an excerpt from a contract, I'll not say which says, for example, the contract shall be governed by the law of the country or other jurisdiction stated in the contract data. If not stated, the law of the country where the works are being done, excluding any conflict of law rules. So you can clearly see that a contract must specify which law governs that contract. Again, bringing you back to the definition that a contract is an agreement enforceable by law. We move. We have a term called freedom of contract, which I'll just touch on quickly as well. It's the abilities of parties to bargain and create the terms of their agreement as they desire without outside interference from the government. So me and Joel Kibiwot, for example, can agree that we want to build a house and I'll pay him 1 Kenya shilling for that house. That's upon us. The government cannot come and say, hey, houses never costed 1 shilling. They cost 10 million shillings or 20 million shillings. Why are you building this house for 1 shilling? That is the freedom of contract that we're having. The terms within those contracts are upon us to create and bargain. But when something goes wrong, the courts of law will assess the contract based on what we agreed upon, only being governed slightly by the governing law. So in most jurisdictions, the courts do not interfere in whatever was agreed upon in that contract, even when a dispute arises. And that's very important to note, which we'll be looking at later. So why would you want, for example, to choose one governing law over another? One reason is familiarity. You need to be familiar with the perhaps you're familiar with United Kingdom laws. Perhaps that's why you studied your legal education, and you just want it to be used. Perhaps you're familiar with French law because France is the country that was the colonial power of your country, and you're familiar with French law more than you are with UK law. Or perhaps you just want to be, because you're familiar with local law, you want to say, I want to use the law of Botswana, for example. Cost of litigation or arbitration. That's also a reason that may make you want to choose one governing law over another. Some governing laws are more complex than others. I'll tell you for free, if there's anybody from West Africa here, the system of law in the western part of Africa is very, very complex because most of it was inherited from the French system, and it's more complex than what the rest of us inherited from the United Kingdom and other parts of our history. Now, we've mentioned something called governing law, and I just want to quickly also mention something called applicable law. I'm building this story slowly so that you see why we need to have standard contracts. Now, in any country, wherever you are, wherever works are being done or construction is being done, because today we're speaking about construction contracts, we have other contracts as well. You have an employment contract with your employer and so on and so forth. But in construction, there are specific laws which, let me pause there for a second. Is marriage a contract? Can somebody tell me if marriage is a contract? Anyone? Oh, I see in the chat. Okay. In the chat, everybody is saying marriage is a contract. Okay. Of course, it is a contract. It's enforceable by law because it's an agreement by two people, isn't it? It meets that definition. Two people have come together with the intention to enter legal relations, and it covers all those. And there's certainty, I believe, and capacity, and so on and so forth. Anyway, applicable laws are laws that are statutes. That was just for comic relief. Applicable laws are the statutes that are relevant to a particular aspect of work. So you have a specific industry. Perhaps you have construction of a gas plant or a hydropower plant, and there are specific laws that govern where this should be situated and so on. You have zoning rules, you have building permits and licenses and approval. For example, when you're building a power line, you need to get permits for way leave and so on and so forth. You have operating licenses and permits. If you're building a factory, for example, you have to get the permits and operation licenses, and environmental matters, which we are all familiar with, and also local and foreign labor. Perhaps we have regulations such as 30% local content. I believe that's common in all our jurisdictions. We have foreign labor provisions. A work permit cannot be more than 1 year, and so on and so forth. So various laws are applicable, sorry, not govern, but are applicable to the contract. So you have your governing law. This is what governs the contract. Then you have the applicable law, specific aspect of the works which are certain law applies to, that is not governed by that law, okay? Now, FIDIC contracts, which is the subject matter of our speech today, are international, okay? And they're generally drafted to be subject to applicable laws. Up to now, I believe I've answered the question, why use FIDIC and not any other contract? Or why use standard forms of contract? But we'll get deeper into that. The reason for this simply is because There's many laws. There's many systems of governing laws. We've seen the three. There's many systems of applicable laws. So you need a contract that if I go to Rwanda and I'm a Chinese contractor, I need not take 6 months to study the Rwandan GCC, for example. If I go to Ivory Coast and I'm a French contractor, I need not take 3 months to study the Ivory Coast GCC, because each country has, and I believe in Kenya, we have the Public Procurement Act of Kenya, and so on and so forth. So each country and each jurisdiction makes their own laws. So what happened is a group of people sat together and they said, let's develop a contract which can be generally used internationally and can be applicable to the laws which exist in that country and can be governed by a specific law. That is an excerpt from a contract, I will not mention which states that, for example, the contractor shall pay rates of wages and observe conditions of labor which comply with all applicable laws. So if this were in Kenya, for example, and a contractor is required to pay rates and wages, they'd have to look for the Kenyan law, which specifies minimum wage, and there's one, which says minimum wage for domestic labor, for example, is this much, for security personnel is this much, and so on and so forth. And the contractor must comply with that, okay? And that is just an example of how contracts deal with applicable laws by generalizing that all applicable laws are established, for example, for labor, which is bullet number 6 above there, okay? It's what we have here. Local and foreign labor. Okay. Before I move to the next slide, I'll welcome quickly the question which we had from, was it Jeremy? Was it? I forget the name of the person who had raised their hand. Must have been Jeremy. Was it Jeremy or Timothy? Okay, perhaps he'll catch up later and then we'll answer that question. So I want to move to the next portion of today's speech. We've spoken about what a contract is, we've spoken about governing laws, and we've spoken about applicable laws. Now we want to speak about something called procurement strategy. And procurement in the context of construction is how a developer or a contracting agent, for example, the Roads Authority of Uganda, or the Roads Authority of Rwanda, or the Roads Authority of Kenya, wants to engage with a contractor. How do you want to engage with this contractor? That is what is called a procurement strategy. We have 2 major procurement strategies, and I'll mention them. Then we'll move on to the others. The first one is called traditional procurement project delivery, where you have an owner or a project developer who engages a designer, you guys, engineers, and you guys, engineers, may engage your own sub-consultants, electrical sub-consultant, mechanical sub-consultant, elevator sub-consultant, lighting, flooring, tiling, and so on and so forth, to assist you in the design. Because if you're a roads designer, for example, you may not exactly know how to carry out the design of electric posts or toll stations and what have you. So you need sub-consultants for those specific parts of the work, isn't it? I believe. Or you may be a roads designer, a materials designer, but you're not a bridge designer. So you need a sub-consultant for the bridges along your road route alignment, just as an example. Then on the other side, the owner is in 2 contracts. The first one is with the designer, and the second one is with the contractor. And the contractor will again engage subcontractors, because the contractor may be specialized in paving works, for example, but not specialized in the construction of toll stations. So that is what we call the traditional project delivery. It's traditional because it's how this system started and it's been carried over and over. Then we have a different procurement strategy called the design, build, project delivery. This is where the owner just gets one entity to do the design, the build, and the construction operations, and perhaps the operation of the facility. And this design build entity may be one legal entity, or it may be a company that gets into a joint venture, meaning company A joins with company B and C, and they form an entity called China Roads and Bridges, and they design and construct a road. So the owner has only one point of contact. You can see the line there. There's only one point of contact with the entity, as opposed to the traditional, where they have a designer, or as you'd call them, consultants, and a contractor, or as you'd call them, the builders. Why is the procurement strategy important in the context of what we are speaking about today? This will answer the question that was raised by Muhindi, I believe. If it wasn't Muhindi, it must have been Daisy. Yes, the difference between, or was it Ochoria from Uganda? The difference between yellow, silver, and red book. This yellow, silver, and red book, and many of the other colors that we'll cover shortly, are designed specifically to answer this question. Which procurement strategy do I want to take as an owner? And there are benefits and demerits of each of these, which we'll not get into. The traditional project delivery has its own benefits, and the design build has its own benefits. And a project owner decides how to get into one based on those reasons. There are many other procurement strategies, okay? We have what's called management contracting, where the works are contracted to a number of different contractors who are contracted to one contractor who will manage them. We also have construction management, where you have the plumbers, you have the electrical, you have the lift contractor, the elevator contractor, and they're all contracted by the employer, but are managed by a construction manager. And we have others, design, build, and operate, where you design, you do the construction, then you operate for a while, recoup your investment, and get out. You've seen that in the toll roads. For those of you who are in Kenya, that's exactly what's happening in the Nairobi Expressway. The guy is here, he did the design, he did the build, he's now operating. Once he gets his money after 27 years, he will go out. We have others, integrated project delivery, PPPs, which are becoming very famous. Again, for the Kenyans, you know the previous scandal that we had with the airport, where we had the guys wanted to come in and, you know, get their money and get out. Since this is not a political meeting, I'll not speak loudly about that. Let's move on now to standard forms of contract. So again, the procurement strategy defines which contract you want to take, okay? If you're engaging in a PPP as a procurement strategy, there are certain contracts which are not suited for PPPs, and there are others which are suited for PPPs. And that is the idea of having all those red, yellow, and silver books. So I hope by this stage that is clear, and I'll now progress to standard forms of contract. Any question up to there before I progress? Any question? Feel free to share a question in the chat box. I can pick it up, or just raise your hand if the microphones are on. I don't know if that means I've allowed the microphones to be on, and I can pick it from there. They say if the class is quiet, either the teacher is very clear or the students do not understand. So I don't know which is the case here today. The class is very quiet.
Everything
Teacher
is
is very
super
clear. Okay, perfect. Perfect. Thank you. I like to hear that. Okay. So let's progress now to the standard forms of contract. What are standard forms of contract? We'll answer that question in a short while. Now, I want to state that a contract outlines 4 things. This is my own wording. It could be more. Maybe a lawyer will tell you it outlines other things. But this is my own wording, and this is my look, my viewpoint on it. What happened there? I drew a yellow line on the screen. Okay. So a contract outlines 4 things. It outlines the risk. It outlines the responsibilities. It outlines the rights, and it outlines the obligations. A risk in the delivery, and I see some of you, good friends of mine who are from the PMP Institute. A risk in project delivery is defined as an uncertain event or set of events that, should they occur, will have an effect on the achievement of one or more of the project's objectives. And an effect here is, of course, negative effect. So a risk is a set of events. For example, if there are protests in the country where you're operating, that is a risk. We're not certain that this risk will occur. It's uncertain. And should it occur, and should protests occur, then there'll be a negative effect in the achievement of one or more of the project's objective. If there's a flooding, if rain falls and there's flooding, that is a risk. Okay? And who bears this risk when it happens? Is it the contractor? Is it the client? Is it party A? Let's speak of party A, and or party B in this case. The contract also outlines responsibilities and obligations. Responsibilities are the duties contained in the contract that each contracting party agreed to do when they signed. And they are now legally responsible for carrying out these responsibilities and obligations. So if you open your contract and it says, you shall report to work at 8 a.m. This is your employment contract. You shall report to work at 8 a.m. every morning from Monday to Friday. That is a responsibility put upon you by the legal agreement that you've entered. And it goes further to say, you shall be paid at the rate of 10,000 United States dollars a month. That is an obligation upon your employer that at the end of each month, they must pay you. If they fail to pay you, you have the legal right to take your contract to a court of law or to the employment court and say, hey, Mr. Employer told me these were his obligations. I fulfilled my responsibility, but Mr. Employer did not fulfill their obligations. So responsibilities are the mirror of obligations, okay? So if you open your contract, or any construction contract, and you see the words shall in English, I believe, means you must do ABCD. So it says the contractor shall excavate to a depth of 1.0 meters. It means the contractor must excavate to that depth. That is your obligation under that contract. On the opposite end of the spectrum is rights. Rights are entitlement granted to a party through a valid contract. Now, these rights may be written or implied. A gentleman called Joel asked about circumstances for EOT. Unfortunately, we will not cover those in this seminar, perhaps in the future seminar. But extension of time in construction contracts is an entitlement. If the rain falls and disrupts your work and it was not your fault, you're entitled a certain right. And this right is expressly written in the contract. So those four things are governed in contracts. Any contract, not just construction contracts, but ordinarily construction contracts have all this. But now construction contracts, I don't know how that yellow line appeared on my, I don't know if it's appearing on yours as well, but it's appearing on mine. And I cannot erase it. So it will be bothersome for us to keep it there, but anyway. So a construction contract has unique characteristics, and you're familiar with this because you've been in them. It's different from a purchase contract, you know, purchase of desks or purchase of biro pens or purchase of pencils and computers. Construction contracts are unique. In what way? Construction contracts are risky, difficult to manage, and often have very low profit margins, which are uncertain. If you work for contractors, you know this for sure. Each contract is large compared to the total turnover. So you hear, for example, this road is being constructed at a cost of 4 billion Kenya shillings. Out of that 4 billion, the profit margin is very, very small. Now, in construction contracts, pricing is done before the actual production, isn't it? You do your tender, you present it to the client, and you agree on the price. In most other places, if it's Nike or Adidas or what have you, they manufacture the shoe, they see how much cost they've incurred in manufacturing the shoe, then they say, hey, we're going to put this shoe out at the price of $15,000 because we spent $10,000 to manufacture it. So they're certain of the profits. In construction, it's quite uncertain. Construction contracts involve lots of variations and uncertainty, as opposed to procurement contracts, for example. If I say I want a HP laptop, I'm certain I want a HP laptop. But if I say I want a road project, you don't know as an engineer or a contractor at what point you're going to hit hard rock and have to change the route alignment if geotechnical survey was not properly done. You don't know when it's going to rain and disrupt your work. it's very uncertain, especially because of the length of construction projects and the environments in which we work. So given this complexity and given this risk and given this difficulty in measuring projects, we move on then to why we need to use standard forms of contracts. The conditions in Uganda may not be the same as those in Botswana, may not be the same as those in Tanzania. So I need, as a contractor working internationally, for example, to be certain of the terms that I'm getting into. And that is where standard contracts come in, to give a fair balance of risk, responsibility, obligations, and rights. A standard form is a pre-prepared agreement with standardized terms and conditions that parties can use repeatedly for similar transactions. So if I come from China today and move to Uganda to do an oil and gas project, I simply carry my standard form of contract, and the employing authority in Uganda also knows and is familiar with that standard form of contract, such that I don't come with my contract from China to meet with the Ugandan road authorities or gas and oil UNOC, Uganda National Oil Corporation contract, which may be conflicting. We have a standard internationally accepted contract, which I can move everywhere and it's accepted. So standard forms of contract ensure uniformity. They're consistent across projects and transactions. They're prepared and drafted by industry experts, engineers, legal professionals, arbitrators, lawyers, and what have you, finance people, accountants, and the rest. They prevent the length of negotiation, because if you have a standard template, and it's well known that we're using a standard template, which is internationally accepted, we have fewer negotiation points of fundamental terms. It covers a comprehensive range of issues, and of course, standard forms of contract balance risk fairly between parties. If you've worked for contractors, you will know that employers would want to draft contracts that favor them, and contractors would refuse those contracts. And it creates a situation where you haggle and bargain for a long time. And that is basically why we use standard forms. You have reduced cost, it's faster during bidding, there's familiarity between the parties, there's more confidence to those who are using it because they've used it before elsewhere, there's less room for deviation, and there's an established body of reference. In case something goes wrong and we go to the courts too have experience with the standard form of contract. So what is a standard form of contract? We have different standard forms of contract around the world. We have the Joint Tribunal, Contracts Tribunal, it's called the JCT. This one is used in the United Kingdom a lot. We have the New Engineering Contract, the NEC. It's developed by the Institution of Civil Engineers, which perhaps some of you are members. And we have FIDIC, which we are going to speak about today. It's developed by the International Federation of Consulting Engineers. Mark you, it's developed by engineers, not lawyers, eh? That's very important because it's an engineer's contract, really. It's not a lawyer's, it's not legal, it's very technical. It's more about the engineering than the law. Then we have IKV, which is by Institution of Chemical Engineers, and many others. Somebody mentioned GCC. It's used in the French or countries which are formerly colonized by the French or have some association with the French. We have many others, which are standard, okay? Now, these contracts are published by specific bodies and are intended to be used for a particular type of contract work. And we'll get into which particular types these contract works are, but today the topic is about FIDIC. Okay. As I've mentioned, we have the NEC contracts. That's how they look like on the screen. You can see this, the one on top is called the Alliance contract. The next one is called the Building and Construction contract. Then we have Design, Build, and Construct, and so on and so forth. They're different, but they're standard. They're tailored for different environments, but each of them is standard. So when you open the Alliance contract, you'll see that all the terms are indicated there. We have the JCT forms as well, the same. We have intermediate building, contractor's design. We have intermediate building contract with the employer's design, and so on and so forth. Then we have what we're talking about today, which is the FIDIC contracts. And the ones you can see on the screen, one is color gray or silver, depending on who you ask. One is color yellow on the cover, and another one is red, you will say. Others will say that's magenta. Depends on how you see colors. I have one here. That's how it looks like in person. It's a book, and it has all these clauses. So it's an actual contract. This one is the FIDIC Conditions of Contract for Construction 2017, and it has about, let me see, about 180 something pages, okay, of standard terms. So if today I leave the project I'm in and I go to a project in the Republic of South Africa, and it's using a FIDIC contract, I need not ask the employer for a contract. I've carried mine. It's standard. Up to there, any questions? Okay, clear presentation. Perfect. Let's move on. One new message. Going well. Thank you, Alice. We're moving slowly. As I said, this is the fundamentals. So I'm building my story. I'm telling you a story from once upon a time, and then hopefully we'll get to happily ever after at the end. So bear with me. Forms of contract. We're going to look at FIDIC contract documents. So as we said, standard conditions of contract for civil works ensure that there is comprehensive coverage of all aspects. There's balanced rights and obligations and risk between employer and contractor. This is a recap. There's acceptability of contractual provisions. And because of this, and because we are living in a global industry, this has led to increased international presence of contractors and owners. I'm sure in the countries you operate in, you have all these nationalities who are doing contracts in there, inclusive of your own nationality. So there's a global presence of contracting over the years that this has developed. And there's cross-border operations. So you need to purchase a generator from China, an electrical part from Germany, and something else from South Africa, and so on and so forth. So there needs to be some structured form of legal and procedural consistency, excuse me. So, as I've said, you have Chinese contractors in government-funded projects, you have Japanese contractors. Some of you are aware of the Japanese International Cooperation Agency, also known as JICA. You have German enterprises in electromechanical works. You may be familiar with these, Italian and French firms, and all this global setup creates a demand for standardized contracts that are widely accepted forms of contract. And this is where FIDIC enters. Somebody asked, what is FIDIC? That is the logo of FIDIC, and FIDIC is an acronym. Is there anyone who speaks French here? FIDIC is an acronym. If there's anyone who speaks French, please read out what this says. Anybody? Any French speaker? Okay, I'll make my best attempt.
Yeah, I speak French.
Okay, perfect. Please, what does it mean? What does it say?
Fédération Internationale des Ingénieurs Conseils. That is International Federation of Consulting Engineers.
Perfect. Yeah. So FIDIC was developed by the International Federation of Consulting Engineers. Now, each country, and I believe your country as well, has a Consulting Engineers Association. Those in Kenya, perhaps you may be members of ASEC, ACEK, Association of Consulting Engineers in Kenya. Those in South Africa, you have CESA, Consulting Engineers of South Africa, I believe. Uganda, it's Association of Consulting Engineers of UG, if I'm not mistaken, and so on and so forth. All these associations of consulting engineers came under an umbrella body known as the Fédération Internationale des Ingénieurs Conseils, the International Federation of Consulting Engineers. So all these consulting engineers from different countries came together under this body called FIDIC. Now, all of them did not come together at the same time. It started in 1913 by 3 countries, France, Belgium, and Switzerland. And a few years later, in 1949, the United Kingdom joined the federation. Incidentally, which is funny, United Kingdom no longer uses much of FIDIC contracts. That's funny. Neither does France, which is very funny. But Belgium and Switzerland maintain the use of FIDIC contracts. So in these 3 associations, and perhaps you can say Switzerland is the mother of engineering, some people like to say that, because of the nature of development and how much engineering they've covered in the country. When these countries came together, they formed FIDIC, and they headquartered it in Switzerland. And it has grown over the years to host members from over 60 different countries, including my own country, Kenya, is a member of FIDIC through the Association of Consulting Engineers of Kenya. Now, back in 1957, FIDIC published its first contract. It was called at the time, the Form of Contract for Works of Civil Engineering Construction. Over time, they saw that they're not only doing civil engineering construction, there's many other constructions. You have mechanical constructions, you have electrical constructions, or electrical engineering, so to speak, or mechanical engineering, and so forth. So they developed other forms. Okay, so this first contract was for the civil engineering sector. Then later on, in subsequent years, FIDIC made certain revisions and expansions to include works which fell outside the initial contracts. I understand where Engineer James has been active in his employment, the Kenya National Highway Authority. They like using the 1984 version of FIDIC, which is about 40 years ago, and there's absolutely no reason to use a contract which was developed 40 years ago. Times have changed. 40 years ago, you didn't have BIM, you didn't have AutoCAD, you didn't have, all these things. So times have changed. And this is why, which will answer the question raised by, who raised that question? The different versions. Daisy from Uganda. Why do we have 1999, 2017? Because the construction industry is ever evolving. So FIDIC as an organization has taken it upon itself to continuously update the terms of contract. What works in 2017 is not what worked in 1999, neither is it what worked in 1957 when the first contract was developed. Okay? So we have, in 1999, FIDIC published a suite of, then it was new, standard forms of contracts, which became suitable for most construction projects. We had the construction contract for works designed by the employer. We had the MDB harmonized contract for bank finance projects only. So you have your Africa Development Bank, you have your World Bank, you have your French Development Agency, China Exim Bank, and so on. This MDB stands for Multilateral Development Bank. So it was harmonized by input from those banks. What would those banks as financiers of these projects want to see in a contract? And all that input was put in the MDB version. We also have the plant design build contract, which I have here. Hopefully you can see it. Hopefully. Plant design build, okay. This is for design and build of plants. Then we have the EPC turnkey contract, which Muhindi mentioned. It's what is called the Silver Book. We'll get into the colors shortly. We have others, the short form of contract, design, build, and operate contract. We have the dredgers contract. We even have a tunneling contract, which was released recently. And this 1999 suite of standard forms of contract developed for different kinds of works is what FIDIC called the Rainbow suite. Rainbow coming from the different colors of the cover of the book. As you can see, this is yellow, this is red, then you have the green and the gold, and so on and so forth. Now, these contracts are used worldwide, the Rainbow suite. And how are they used? Where is my slide? How are these contracts used worldwide? You have the conditions of contract for construction. This is for use on building or engineering works that have been designed by the employer or a representative of the employer. So if you're working for KenGen, Kenya Power Generating Company, KenGen, and you're the employer and you want to design a hydropower project, you employ Road Sub Consulting to design the hydropower for you. That's called your representative. And you call a contractor, hey, Mr. Contractor, China Roads and Bridges, come and construct this hydropower for me. You have done the engineering works as the employer and you're handing over the construction to a contractor. And that is what was called the Red Book. And the cover is color red. Then you have the construction contract for plant and design build. This is for provision of electrical and mechanical plant. For those of you who are in the electrical field or engage a lot with electrical fields, perhaps people who work in real estate, there's a lot of that in there. You have the yellow book. It's for plant and electrical or mechanical plant designed by the contractor. Ordinarily, an employer would not be familiar with a lot of electrical and building stuff, which is contracted to specialist contractors. If you have an elevator being installed in your building, for example, you may not be very familiar as a real estate developer with how elevators work. So you want the contractor to do the design and do the building and installation of that plant for mechanical. And this happens in power plants, this happens in hydropower, this happens in dams sometimes. And the color of that book is yellow. Then you have the turnkey projects, or the engineering, procurement, and construction, EPC projects. And this one is for the provision of a turnkey, right? I, as the employer, lift my hands up, and I just want you as the contractor to come in and give me the key so that I turn my factory and power it on and it starts functioning. So why would an employer choose the red book over the silver book, for example? If the employer does not have capacity or specialized knowledge to carry out the design, you're better off giving it to a company who will give you the turnkey, who will do the engineering, procurement, and construction. And this is very common, especially with power transmission lines or power plants, which the employer does not have the in-house capacity to do the design. And many countries are shifting to that because government, especially government agencies, if I may, because you want a contractor to do everything and you lift your hands up, okay? And the color of that book, as you may correctly guess, is silver. Then you have the short form of contract, which is for use on short contracts. It's really brief. It's, I think, 60 or so pages or 20 pages of contract. And the color, as you may guess, is green. I've mentioned the multilateral development banks, the international financing agencies, such as the World Bank, Africa Development Bank. They came together and spoke to FIDIC and had their thoughts incorporated in a contract, which is now called the Pink Book, and its cover is pink. That's how it looks. Then you have the conditions of contract for design, build, and operate. I began the seminar by mentioning sometimes as an employer, you want a contractor to come, do the design, do the construction, and do the operation. And after they recoup their finances, they'll ship out and leave the facility to you. The best FIDIC book to use for that is the Gold Book. I hope I've not lost you so far. That is how FIDIC books look like. Again, you have the red, yellow, and silver. This is the 2017 suit. So what we're looking at previously is the 1999 suit. I think in 2017, FIDIC decided, let's keep matters simple. We need only these three kinds of books. The rest can stay back in 1999. And so these cover most aspects of construction. The silver book for EPC, the yellow book for plant and design, and the red book for works designed by the employer, 2017 versions. So that, I hope, answers the question which was asked, why 1999, why 2017? It's simply a development of knowledge. You'll notice, for example, which we'll not get into, but in 2017, we speak about BEAM and so on and so forth, which was not there in 1999. So just a period of how many years ago? 8 years. A new technology has arisen, which overrides a lot of the technology that we used to use in 1999. How do you know which form to use? To answer this question, you must answer the following questions. How complex is the project? Is it something you as an employer can carry out? Is it a simple 10-kilometer road with only one pavement? Who carries out the design? Do you as the employer have the capacity or any of your agents to do the design? Or do you want the contractor to do this design because it's specialized works? It's perhaps a toll station road which needs specialized engineering, which you as an employer do not have, or history, or you do not have the expertise. Is there certainty about contract price and contract time? Do you want this project? Is it urgent? Must it start operating at a certain time? Or is time not of essence? What level of engagement do you as an employer want to get into in the day-to-day execution of the project? Or do you want to delegate it to an engineer from Broadsham? And is there some maintenance required? Or does the employer want a turnkey project? If you answer these questions, then you should be able to know which contract to use. I have a graphic which I'll take you through quickly. I see we have about 12 minutes left, and I think I'll be able to cover all the material for today's session. If it's a straightforward project and the answer is yes, then you use the green book, the short form of contract. It's straightforward, maybe a 10-week project or 5-week project. Use the green book. It's simple. It's a short form, does not have lots of complexity. It's not a straightforward project, and the employer wants to do the design. Is the employer doing the design? If the answer is yes, then you use the FIDIC Red Book or the FIDIC MDP harmonized version. Okay? If the employer is not doing the design, then that means somebody else is doing the design. Who is this person? It's the contractor. If the contractor is doing the design and it is plant, and plant here we're not meaning vegetation, but we're meaning equipment, mostly mechanical or electrical equipment, and there are high and unforeseen risks. If the answer to that question is yes, you ask yourself, will it need maintenance? Or once the contractor does the design and builds, I, as the employer, will take it over. If the answer to that is yes, then you use the design, build, and operate, if there's some maintenance. If there's no maintenance, then you use the plant and design build. The contractor does the plant, does the design and the build, and they ship out. There's no operation, there's no maintenance. We come back. If it's the contractor doing the design, but there are no significant risks involved, unforeseen risks, right? Then you want to do a fixed lump sum. So you don't want, as an employer, to be highly involved in the project, and there are no major unforeseen risks. What do? You choose the silver book, the EPC turnkey. So you want to lift your hands as an employer, you want the contractor to come in, you want the contractor to do the design, the engineering, the procurement, and the construction, and give you the key, that when you get the key, all you do is turn the key. You use the silver book. If it isn't, then perhaps you may need to discuss in detail the employer requirements and negotiate a modified FIDIC contract. I hope that is clear, and maybe a lot of questions will arise from here, but I believe that part is clear. Another question was asked. I want to know the general structure of the contract. Who was this? Structure of FIDIC contracts. This was Daisy from UG. As we've discussed, FIDIC forms are tailored through different scenarios. They share a common structure and purpose. There's a common structure. If I open a FIDIC contract here in Kenya, it's the same one you'll be opening in Rwanda or in Botswana or wherever you are. FIDIC contracts are divided into two main parts. The first part is what is called the general conditions. Now, the general conditions set out the standard contractual terms. We say FIDIC is an example of a standard form. This is standard, it never changes. It's the same. It covers the rights and obligations of both parties. We started by speaking about rights and obligations. It includes procedures for payment, variations, somebody asked about variations, certification, and dispute resolution. Somebody else asked about dispute resolution. All that is contained in here, in the part 1, general conditions. Then we have part 2, conditions of particular application, or sometimes you may hear somebody say the special provisions. So these general conditions, I'm working on an oil and gas project in Uganda. How do I modify or particularize the application of these general conditions to suit the project-specific needs of the project that I'm doing in Uganda? It will include terms like contract language. What is the contract language? What is the contract language that we'll be using in communication? Is it Kinyankole? Is it Luganda? Is it Setswana? Is it Zulu? You describe it in the conditions of particular application. That is not contained in the general conditions. That is for you as a contracting agency to prescribe in what is called special provisions or conditions of particular application. Governing law, we spoke about that. It also states who is the engineer. Is the engineer road sub-consultancy? Or who is the employer's representative? Is the employer's representative Mr. Boikobo Chelane? It specifies all that in the special provisions. Now, the conditions of particular application, there's guidelines in here of how you can draft these clauses. So if you're ever charged with the role of drafting the particular applications, please open your FIDIC general conditions, run through to the back, there's guidelines on how you can draft those ones. It says, for example, I'll just quickly read here. It says, for example, the engineer's duties and authorities. It says the engineer shall obtain specific approval of the employer before taking action on the following conditions, subclause, subclause, subclause. So it states how you're going to write the particular applications. The general structure of FIDIC contracts also contains what is called appendices, which are the sample letters which you can write when you're writing out to tender, draft contract agreement. As I started at the beginning, I said a contract must have an agreement, whereas party A and party B have agreed, and whereas in view of the services offered and so forth, that's what's called the contract agreement. And dispute adjudication agreements, which Mr. Oracle will be very familiar with. So those are also contained in the FIDIC standard forms. But now a construction contract is not only FIDIC. I'm sure those of you who have interacted with it and the many engineers here will agree. You have the first part, which is the agreement, which states that party A and party B have agreed to come together, and it covers the 7 elements of contract which we spoke with in the beginning. This is the consent, this is the offer, this is the acceptance for this consideration, and we are legally binding ourselves. Then it has the particular conditions of contract, which we've just spoken about now. Then it has the general conditions of contract, which is the standard form of FIDIC contracts. Then we move on to the specification, which engineers love to prepare, but never read on site. Then we have the drawings, which engineers love to prepare and love to read on site. Then you have the bill of quantities. Now, a construction contract is ordinarily comprised of this. So all this must be read in entirety. You do not read one and leave out the other. So FIDIC only covers the general conditions, and you as an employing agency or a developing agency, you'll draft your particular conditions based on what FIDIC guidelines say, and you have your agreement, and you'll develop your specification as an engineering department. The drawings will be developed by your drafters and checked by the engineers. The bill of quantities by your quantity surveyor or your project manager or whoever is in charge, your finance department and so forth. And all these form the contract. So in case of a dispute, we say the contract is legally enforceable. What happens? You go with all these documents to your arbitrator, and they look at all of them and they enforce it. Who are the parties in a contract? Just before we finish, as we are left with only 4 minutes. We have the employer in construction contracts, of course, not other forms of contracts. The employer is ordinarily the financier and the owner of construction projects. The employer is ultimately responsible for the project success, and they're the Mr. Moneybags. They may get financing from elsewhere, but as per the contract, the financier, World Bank is not a party to your contract. JICA is not a party to your contract. It's you as Uganda Rural Roads Authority or Kenya Rural Roads Authority. It is you as the employer who gets a contractor appointed by you who oversees all the aspects of the construction. And this is what we call delegated authority. So you give the site to the contractor, and the contractor performs their obligations. We spoke about obligations, and you as the employer are obligated to make payment in consideration for the agreement that you had. Now, the contract is only signed between these two parties. So these two are the parties to the contract. The engineer is not a party to the employers and contractors' contracts. The engineer has a separate contract with the employer. Perhaps I should use a different color for that. Okay, so the engineer is in a different contract with the employer. This is called a service contract or a consultancy contract. These two contracts are separate. The employer contracts the contractor to do the works, and the engineer is an expert selected for the project, perhaps to do supervision, perhaps to do design, perhaps to ensure or to do contract administration and so on and so forth. So these two are separate contracts ordinarily. They're never the same contract if you're using the traditional procurement method, which we spoke with at the beginning. So those are the parties to a contract. Of course, you'll have others. You'll have subcontractors. They're not party to the main contract. Okay, you will have BIM providers, they're not party to the main contract. You'll have environmental experts, they're not party to the main contract. You can have other subcontract or sub-consultancy agreements to cover those different aspects of construction. So lastly, I'll cover the structure of FIDIC forms, which, as I've mentioned before, we have the 1999 version, which was later updated in 2017. And generally, they have 20 clauses. Each clause covers a specific aspect of construction. And in the 2017, it was expanded to add one additional clause. We'll see which one shortly. The Green Book, which is the short form of contract, has fewer clauses. It's just 14 clauses. These clauses may be viewed as covering various thematic areas in contract administration, and there's very little minor variations between the different forms. It's out of the scope of today's seminar, but in future, you may be able to see why silver is different from red in what way, despite having the same number of clauses. I have a graphic there, which shows the FIDIC 1999 on the left and FIDIC 2017 on the right. These clauses, this is my own division as to how I understand it. So you'll not see these terms in the contract when you open it. This is how I define it. Because I've looked at clause 1, it gives general provisions, general items and definitions. It says, what is a drawing? It says, where is the site located? Such things. Clause 2, 3, 4, and 5 speak about parties to the contract. Who's the employer? Who's the engineer? Who's the contractor? What are their rights, roles, responsibilities, and obligations? All that is defined there. In the Red Book and the MDB, clause 5 is about subcontractors, but in the Yellow Book, clause 5 is about design. Then we move on to another theme, which is execution of the works. Staff and labor is covered, plant, materials, and workmanship. So as an engineer, you'll be keen, if you're a materials engineer and you're seated here, you'll be very keen to look at what clause 7 of your contract says, plants, materials, and workmanship. If you're an administrator, perhaps you're a site manager, you'd want to see what staff and labor says in your contract. Then we go to time for completion and execution. The contract speaks about commencement, delays, and suspension, speaks about tests on completion, employers taking over, defects liability, tests after completion. This is clause 8 to 12. It's the same in 1999 and 2017, but with significant variations as to what is contained in there. Then you have financial control. If you're seated here and perhaps you work in the finance department or the procurement department, these 3 clauses will be of interest to you. Clause 12, 13, and 14, measurement and evaluation, variations and adjustments, contract price and payment, and so forth. Then you have, I think it's called differently, not variations and adjustments in 2017. That may be a mistake on my part. I'll correct it for future. It's actually called variations and adjustments. Oh, so it's correct. Okay. So then you have the risk and the liability, termination, suspension. This is legal stuff, and force majeure. This is all legal stuff, and blah, blah, blah. What happens when you want to terminate? What happens when you want to suspend the works? And so forth and so forth. Then you have what somebody asked, claims, disputes, and resolution. Unfortunately, we've run out of time, but in future seminars, we'll be delving into some of this and see how FIDIC handles claims, how it handles disputes, and how it handles arbitration. We'll also look at how it handles the extension of time in future. Somebody had asked that. Where is that? Extension of time. Somebody had asked how it, FIDIC addresses that, and perhaps we'll find time in future seminars. My time slot was from 8:30 p.m. East Africa time to 9:30 p.m. I've exceeded by 2 minutes. My apologies for that. But I would welcome any questions in the remaining few minutes before I hand over to Engineer James and the team at Rhodes Hub. Thank you once again for inviting me. Thank you for attending. Otherwise, I'd not be speaking to 100 people this afternoon. And I wish your team all the best of luck as you go for the football match this evening. Any questions?
Yes, thank you, Engineer. I hope you can hear me, all right?
Yes, I can hear you quite clearly. Godfrey,
okay, thank you. Yeah, my name is Godfrey Kalendu. I'm from Uganda. Engineer, thanks for the for the mentorship class. It has been so much wonderful. But I have some inquiries, engineer. Does this FIDIC apply to oil and gas projects? That is my first question. The second question is there any difference between EPC projects and DBOOM? DBOOM, I mean design, build, own, operate, and maintain. That is. And then the third question, which rainbow suit is for the oil and gas projects? Thank you.
Okay, thank you. Thank you for that. Thomas, your hand is up. Thomas Tumusime, I think. What does the name mean, Thomas? If before you start your question,
Yes.
please tell us what
Yes,
Tumusime
thank
means.
you. Thank you, engineer. I hope you can hear me.
I can hear you.
Oh, my question, I'd actually put it in the chat. It's a little bit of maybe not so much to the content, but I was asking if someone really needed to know contract management in detail, maybe how and what course and where can someone go or study from?
Okay, thank you for that. Is there any other hand up? I can see some questions in the chat by Alice. How often is FIDIC updated? I'll answer that. Matthew Ochoria says most FIDIC related contracts are so pricey. How can one? I think that relates to Thomas's question as well. What does it take? Okay. What is the difference between yellow and silver? I thought I'd cover that, but I'll cover that again. Kindly explain the rainbow suit using the procurement strategy too. Will you share? Oh, Anthony. Hi, Anthony. Will you share the presentation material? Yes, Roadsup will be able to share it. If someone wanted to learn contract management, that's the same as Thomas. Jennings, what are the responsibility of a resident? I'll answer that. Okay, quickly, let me go through these questions. Thank you, Whitney. Wonderful presentation. Great presentation, Boikobo. Let me go through these questions and then I'll do the last four and then close. So, Kalendu asks, oil and gas, does FIDIC apply to oil and gas? Yes. FIDIC conditions of contract apply to oil and gas, but which specific aspect of oil and gas? If you're speaking about the joint venture, then perhaps not. If you're doing a joint venture, you need other contracts. They're standard contracts for joint venture. But if you're speaking about engineering, procurement, and construction, certainly it applies to oil and gas. What's the difference between DBOOM and EPC? EPC is engineering, procurement, and construction. The contractor does the engineering. The contractor decides which design they're going to procure, which kind of elevators they're going to install, which kind of generators, which kind of power, solar power systems. They do all that. They do the engineering and the procurement and the construction. So the employer does not even prepare specification. They only prepare requirements. I want a solar plant that can give me 10 megawatts. Up to you, Mr. Contractor. Design, build, operate, and maintain is slightly different. So the contractor does the design, but based on employer's requirements, not based on their own engineering, based on the employer's requirements. They do the design, they build, they own, they operate, and manage or maintain. And finally, after they've recovered their money, obviously because they financed the project, they'll hand it over to the employer, usually after a given period, 25 to 30 years. So that is the distinction, and I hope it's clear. How to learn and where? Wow, that's a difficult question because I see somebody else, I think this was Mr. Ochoria saying that there's, who said it's very expensive. Yes, it was Matthew Ochoria said FIDIC related courses are expensive. Yes, that is true. You can go to the FIDIC website. I'll ask Roadsup to share a list of places, but we can cover this in future of places where you can study FIDIC contracts. One of them is the FIDIC website. It's quite pricey on there. There's other institutions which offer detailed training. And very soon, I will be launching my own training, which I'll be inviting you to join. And it will not be pricey. It'll be at a fair price that you may gain all this knowledge, because this knowledge is free. And so it should be freely shared, isn't it? Of course, at a small price, just to cover for logistics. Soon I'll be sharing with you how you can undertake these courses and be certified through my own institution. How often is FIDIC published? This was asked by Alice. Alice, FIDIC is updated. The last update was in 2017. I understand there are new forms which are coming up in 2025. So there's no fixed period. I think as an organization, FIDIC sits down and decides what we have in this contract is updated based on the progression of the engineering field. So they decide to update it. What's the difference between yellow and silver? Yellow is for plant and design. Silver is for engineering, procurement, and construction. So for the yellow book, and there's actually very slight differences, you're right, very slight. But for the yellow, the contractor is given employer's requirements and does their own design, but it's suited for plant. And as I said, plant here is not vegetation, but plant ordinarily is electronic, electrical, or mechanical plant designed by the contractor. So you're talking about your hydropower, you're talking about your data centers. These are electrical and mechanical plants which are designed, your solar power plants designed by the contractor. Engineering, procurement, and construction could be anything really. Could be a factory. You want the contractor to design a meat factory, meat processing factory, for example, or a textile factory. And they do the engineering, they sort out the procurement, and they do the construction. So that is a very slight difference. Perhaps in future, or if you enroll in the course which I will soon launch, we'll go into the detailed differences of how yellow is applied and silver is applied and where. But I believe that was covered in the slide that I presented. This slide here, I believe it was covered in this slide. So basically, the silver book is for where you want little employer involvement and there are no major risks. But if there are high unforeseen risks and there's no maintenance required, you need the design and build, the yellow book, okay? Kindly explain the rainbow suite using the procurement strategy too. So the procurement strategy, look, you have the traditional design. These ones here are the traditional design. By these ones, I mean these ones. I'm drawing the wrong part. These ones are the traditional design, okay? These ones are the design and build, okay? And this one is the lump sum or other integrated project delivery methods. So depending on which procurement strategy you want to adopt, then you can choose any of this. How much as an employer are you willing to get involved in the day-to-day running of the project? If you don't want to get involved, choose the silver book, let the contractor do everything. Anthony asked, will you share the presentation? It will be shared. If someone wanted to learn contract management, where do they go? There's several online resources. FIDIC is one of them. They offer the course online. In the FIDIC Academy, you can just type in Google FIDIC Academy and you'll find it. And it's quite costly. Others exist as well. And you can, I'll give Rods up who will distribute to you a list of places where you can study FIDIC. What are the responsibilities of resident consulting engineer on a traditional contract? The responsibilities will be as defined in the contract, okay? What did we say the contract defines? Risks, responsibilities, obligations. However, ordinary responsibilities involve things like supervision of works, carrying out tests. So the resident consulting engineer will also handle the claims, for example, do material tests, check the defects, do the measurement and valuation of the works, prepare the certificates of payment, receive correspondence and prepare correspondence. So there's a host of consulting engineer roles in ordinary projects. And in future sessions, we'll look at the specific roles clause by clause. But generally, it's as is defined in the contract. Thank you, Mark, as well, for appreciating my efforts. I appreciate your attendance. The recordings, RoadsApp will be able to share the recordings through Engineer James. Wonderful presentation. Thanks, Whitney. Hillary. As a mechanical engineer, I wish to purchase a machine from another country. The supplier will be responsible for installing it at my company and after successful commissioning. I wish anybody in the chat can answer this question because I think I've covered it. Somebody? Let me pick somebody so that we don't take time. Boykobo, please answer that question. What do you think? Boykobo, please.
For the machine, I
Yes,
think
Hillary in the chat is asking, as a mechanical engineer, he wants to buy a machine from another country. Supplier is responsible for installing it and at his company and commissioning, then handing over. Which form should he use?
should use the silver book.
The silver book, engineering, procurement, and construction. Why do I think you should use the yellow book?
The yellow book, precisely.
I think
Because
so, right?
the yellow book doesn't include the maintenance, right?
Yes, does not include the maintenance. It will be handed over to Hillary.
Yes.
Okay.
Yes. Yes. All right.
Thank you. Thank you. Matthew Ochoria, I was waiting for you to say you'll be starting the course. Please be fair. Yes, I'll have a fair pricing for the African market, of course, or discounted prices, of course, and you shall be waiting. Thank you. Engineer James, nice to see you. Some senior professionals, you are one of them, claim that newer versions of FIDIC tend to favor the contractor. Yes, that is true. I do not like the newer versions now that I'm working on the employer side,
Yeah,
but if I'm working
okay.
for the contractors, I'd be very happy working with the newer versions. Mr. Samuel, does FIDIC contract apply to contracts between main contractors and subcontractors? Yes, we have a FIDIC contract subcontract form. Unfortunately, I didn't cover it in my presentation, but that is true. We have a specific contract for FIDIC subcontractor. And I see Mark has answered, yes, 1999 edition. We have the FIDIC subcontractor, FIDIC form. It's called the FIDIC subcontracting form. That's what it's called. And it looks like the red book, only that it's slightly different. Yellow book, okay, Anthony has answered. Good job, Engineer Barasa. Thank you, Engineer Paul. The engineer is appointed by the employer. Yes, that is true. On the RE question, the engineer is appointed by the employer and the employer gives them the terms of engagement. I believe I've sufficiently covered the material I intended to cover. And I know a lot of questions will be arising, but we'll have future opportunities to speak and we'll be able to cover much, much more in those future opportunities. Thank you once again for taking time to join us. I really appreciate your company this evening. Last question by Kalondo, is FIDIC applicable to JV and MOU? That was your question. For oil and gas, JV and MOU for oil and gas, there's specific contracts for JV and MOU, right? FIDIC does not have one. It's developing one in 2025 for JV, but as of now, there's no one for JV and MOU in oil and gas. But for EPC, you can use the FIDIC Silver Book. I hope I've satisfactorily answered your question. For JV, you can go to the United States one. They have a standard contract, which I think is the one which is used in all oil and gas projects. Thank you. We really have not much more time. I'd really beg to end here. We'll have future opportunities to interact. And thank you very much. Back to you, Rosa. Back to you, James.
Moment, but I want to take this moment to express my gratitude in the most humble and sincere way to Engineer Barasa Ongeti for creating time and first for honoring the call to come and educate our community. Secondly, of course, for his humility to take us through this session, to share his expertise that he has accumulated over the last decade freely to all of us to build a foundation on. And of course, also his willingness to respond to all our questions and of course, be able to guide us even in the future sessions that we may plan. So I want to say very thank you. I don't know how much I can say thank you, but you deeply know that the entire community is very grateful and we are very humbled to have you here. To every one of us who was locked out, I think this is the sign of the universe that we need to expand our capacity, and we hope that also in the next sessions we'll be able to accommodate all of you. The recordings shall be shared on our LinkedIn page and YouTube, so please you can check out Ronsab, and most importantly check out Barasa Ongeti you need to talk to him. He's such a kind gentleman and he will always respond to you. So Barasa Ongeti with an S, Barasa, not Baraza. Barasa Ongeti, and he will be able to respond to all of you. Should you also be having a challenging contractual issue that you need consulting, you need his expertise, so please shoot him a DM, and he will be able to respond to all of you and also help you be able to, handle any project challenge that you have. One more time, of course,
Chris,
he will be launching his program to train engineers on application of FIDIC contracts across various sectors based on his expertise and experience. I will be able to share it out with you people because you deserve to learn from the best, and so also so you can improve
you guys are
your
good.
careers. So thank you. Thank you.